Government cannot take over private property as India is a liberal country. This was the crux of the Supreme Court's landmark judgment related to Article 31C and 39B of Indian Constitution, and it overturned a series of judgments from the past. The hearing questioned states' power to acquire privately owned property for the greater good of the community. Not all privately owned properties qualify as community resources that the state can take over for the common good, the Supreme Court said in its verdict today. The 9-judge Constitution bench led by Chief Justice of India D.Y. Chandrachud delivered the judgment on the contentious issue with a 8:1 majority with Justice Sudhanshu Dhulia dissenting. An important note of the court was that India is of a liberal economic ideology rather than socialist. The period of time when these laws were laid down are of a period when Indian society was more socialist in nature. Article 39B lays down that the state shall direct its policy towards ensuring that the ownership and control of the material resources of a community are so distributed as to best subserve the common good of the community. The court was listening to petitions by Property Owners Association of Mumbai to Chapter 8A of the Maharashtra Housing and Area Development Act (MAHADA), introduced in 1986. This allowed the state to acquire Mumbai's old dilapidated buildings termed as cessed properties in favor of cooperative societies of the occupiers. This amendment contained a declaration that the Act seeks to give effect to the state policy for securing the objective specified in Article 39B of the Constitution. Simplified, the MAHADA Act used 39B of the Constitution to justify taking over of cessed properties, and the property owners of Mumbai were displeased with it. The state had claimed that housing stock is a material resource of the community, and the construction or reconstruction of the building is for the common good, as old buildings are and can be unsafe. However, the property owners have opposed the state's move by arguing that Article 39B cannot comprise privately owned property. In 1977, a 7-judge bench had ruled with a 4:3 majority that all privately owned property did not fall within the ambit of material resources of the community. In a minority opinion, however, Justice Krishna Iyer held that both public and private resources fell within the ambit of material resources of the community under the Article 39B. During the hearing today, the Chief Justice pointed out that Justice Iyer referred to communist ideologue Karl Marx in his judgment. Quote, "The judgment is rooted in the economic ideology that private property can be used by the state for the welfare of people. The role of this court is not to lay down economic policy but to facilitate to lay down economic democracy." Unquote. He also added that the country's economy has shifted from socialist approach to a liberal economic regime, and so that interpretation of Article 39B cannot be applied. In her separate judgment, Justice B.V. Nagaratna disagreed with Chief Justice on his observations regarding the ruling by Justice Iyer. Quote, "Justice Krishna Iyer advocated on the material resources of a community in the backdrop of a constitutional and economic structure that gave primacy to the state in a broad sweeping manner. As a matter of fact, the 42nd Amendment had included socialist in the Constitution. Can we castigate former judges and allege them a disservice only because of reaching a different interpretative outcome?" Unquote.